Good afternoon. Welcome back for the next session. And we already have our guest with us today, none other than Ms. Hasti Chandarana. She is a dynamic patent attorney and IP strategist known for her interdisciplinary expertise in pharmacy, law, and intellectual property rights. She is a registered Indian patent agent and an alumna of Government Law College, Mumbai, and Dr. Manovan Nanavati College of Pharmacy, bringing together scientific depth and legal precision in the domain of patents and innovative law. With over 4 years of professional experience, she has worked with leading IP law firms and served the UK Intellectual Property Office, UK IPO, through the British Deputy High Commission. She currently leads IP management, commercialization, and policy development as the IPR executive of SBKM. Beyond her legal and academic roles, Hasti is the chief legal strategist at Allegheny Wellness Foundation and a committed advocate for chronic health awareness, particularly through her work with the Diabetics Foundation on type 1 diabetes rights and healthcare access. She holds international certification from prestigious institutions including WIPO, Harvard, and NLU Delhi, reflecting a strong global perspective and a passion for shaping India's innovation ecosystem. Her key areas of expertise are patent law and IP strategy, filing and prosecution of patents in India, IP policy and institutional IP cell development, IP commercialization and licensing, advocacy in health rights and public policy. I request her to take over the session. Thank you.
Yes, so I've been working in the field of IP for over 4 to 5 years now, and currently I'm serving as the IP executive at Sri Vilaypalle Kilamni Mandal Institute. So I look after all of the IP filings and commercializations at all 59 institutes of SVKM. So that is a bit of my technical background. And today, this session is on specifically on trademarks and copyright. At my previous role, I was the head of all of filings of trademarks and copyright. So I think maybe I can share some of my learnings and with you. Please feel free to interrupt me, ask me questions. Agar aapko kuch samajh nahi aa raha, ask me anything and I'll try my best to answer them. Yeah. So just to give a brief, I know aap log 4 days se you all are listening about intellectual property. So if I can ask you all, what does IP, what do you guys mean by IP from the last 4 days? What is your understanding of intellectual property, if I may ask? Anybody willing to? Ma'am, if may I ask you, what do you mean by intellectual property from what you heard over the last 3.5 days now? What comes to your mind when we talk about intellectual property?
A novel idea, right, which come from your brain and your work on some scientific project or some formulation or something innovative and you want to register it on like patent agent.
So novel idea and some innovative research. That is one thing. Anybody else with any answer for what IP means for them? Anyone in the, yes ma'am.
Something that is intangible, cannot be seen.
Yes. Perfect. Intangible. I think IP stems from protecting your intangible assets. So yes, intangible.
That has a commercial aspect.
Something that has a commercial aspect to it. You mean you are touching on the essence of the intellectual property which you can then commercialize. Yes. Anybody else? Any other understandings of IP? In the back, anyone? One word answer also, what do you think about IP? Sir, any thought that comes to mind जब मैं IP बोलती हूँ या intellectual property की बात करते हैं, आपके mind में क्या एक word आता है? What do you think intellectual property means? Patent. Okay, so we heard answers of novel ideas, experimental research, patents, commercial. Yes, all of this comes under the umbrella term of intellectual property. Basically, any of your intangible ideas, expressions, creative works, all of that come under it. Over the last 3 days, we heard about the technical side of intellectual property. You have something, you have done some scientific research, you have come up with a new design, then you go for a design registration. You heard a lot about patents. But anybody of you has any idea of what copyright means? So basically today we'll start with copyrights and then I'll move on to trademarks. Because I feel copyright is very essential for academicians. आपके काम में every day you all do publications, research work, literary works. So all of that comes under the criteria of copyrights. So anybody, when I say the word copyright, what do you think? What does it mean or signify for you? Have you all seen on any websites, on TVs, anywhere copyright reserved, copyright belongs to the author? Those terms, or basically, your copyrights protect your creative expressions. Patents cover your novel technical solutions, whereas copyrights create your ideas. Not just the ideas, but the expression of ideas is what is protected under copyrights. Copyright is the only type of IP right which inherently exists. Patent आपको granted certificate चाहिए, you have to go through the whole process. आपको register करना पड़ेगा, you'll have to disclose the information, and the process, I'm sure that sir explained it to you over the 3 days. You need to get that certification to have a patent. Similarly, for designs, you need to file for a design और फिर आपको वो industrial design certificate मिलता है, which is then valid for 10 years. Same way, trademark ka, you can use trademarks, brands, identities, logos, but you still have to apply for a trademark to get the protection that it entails under intellectual property rights. Copyright is the only unique IP as soon as you make it. As soon as you make any original work, copyright exists. Copyright registration सिर्फ इसलिए करते हैं that it acts as a proof कि okay, this right or this work is my own. Copyright protects all sorts of creative expressions that you come up with. So there is a category and different types of copyrights that can be applied for. So we'll start. The basic 3 broad categories are literary works, artistic works, dramatic, musical, sound recording and cinematographic films. Literary works में क्या-क्या include होगा? You made any new stories, any research papers, review articles, any short concepts, the concept of how you develop a film or anything new that can be done in a written form will come under literary work. Computer programs, any app that you develop, how do you protect an app? Under the Patent Act, apps and computer algorithms cannot be protected. Design है नहीं app में, there's no 3D feature in the app, so you cannot protect it through industrial design. How do you then protect your apps that you come up with? It comes under literary works. So there's a different category जिसमें वो app develop करने के लिए आपने जो भी algorithm use किया या computer program language use किया है, that gets protected through literary work under copyrights. In the same way, आपके ऐप में और any other work में you might come up with a new painting, a new drawing or a new logo. All of that will come under your artistic works. आपके website पे there are new logos, animations, caricatures that you have made. All of that comes under the criteria of artistic works. So copyright में there is one important distinction कि you have to apply for the specific copyright. Suppose you have come up with an app or a website. वो website का computer language है, वो will come under as a computer program, a separate copyright. The content of your website will come under a literary work. If there are any logos or artistic work on it, that will be registered as an artistic work. उसमें आपके website में कोई video है, कोई sound recording है, so that will come under a separate work. So copyrights are divided into the type of work it is, and in that format we file for the protection of it. So literary, artistic, dramatic works. Dramatic is any movies or any performance that I am doing. My performance of conducting this session also comes under a dramatic work. So if I want, I can also file for the copyright session. आज का जो video ले रहे हैं, I can file for a copyright protection for the same. And then it is my right that this video cannot be shown to anybody else without my permission. And that is the right a copyright protection gives you. Musical work is, so for example, you come up with a song. How many types of copyrights do you think उसमें exist करते हैं? एक song है. How many types of copyright would there be in it? Anyone, any clue? Based on these 6 types. Or do you think it's one copyright musical work में आएगा? Yes. Perfect. So there will be literary work, जो lyrics है of the song, that will be protected under literary work. जो artistic, if there's a video shot and उसमें कोई artistic animations है, that will come under artistic work. Musical में the composition of the song will come under musical work, and the sound recording, the entire song. So the sound recording is protected and given to the singer. Musical composition producer को मिलेगा, and the overall song जिसका पूरा production किया है with the video, that will be granted to the producer of the song. So different types of IP exist in one single song. So there are different types of copyrights, different ways of protecting this. There's one very key differentiation in copyrights. Patents में it is defined who is an inventor, कौन है, who has the rights, and who is the applicant. There is a bifurcation in patents की. There's this one person who is the inventor who came up with the idea, who developed the technical solution, and they filed for it. And an applicant can be the same person or a different entity. Suppose एक organization, एक company है, तो the applicant will be company, और उसके employees or the researchers will be the inventors. Similarly, in copyrights, the author is the one who comes up with the expression. And in copyrights, it is considered, अगर आपने कहीं mention नहीं किया कि the owner is different, it is considered that the author is the owner of your copyright. So when I talk about literary or dramatic works, the author will be the one who came up with the literary work will be considered as the author and the owner of copyright. When I talk about musical works, the composer will be considered as the author. When I talk about cinematographic films, the producer will be granted that copyright, unless he assigns it to someone. Sound recording mein, again, as I just described or explained, producer will be considered. So there exists copyright in the photographs also taken. There was a very unique case कि a photographer took a photo of a monkey in the zoo. He was smiling and doing some sorts of theatrics, और वो बहुत unique expression दे रहा था. And then the photographer took the photo, और वो photo उन्होंने publish कर दिया. Getty Images करके एक publication है, उनके website पे वो photo आया. Now begin the circus कि कौन own करता है वो copyright. Photographer own करता है, या zoo जिसमें वो monkey था, they own the copyright, या the publication जिसने ये photographer को hire किया था, he owns the copyright. Who do you think owns the copyright of the photograph? Photographer, but he was under employment of the publication house जिन्होंने उनको right दिया था. And why not the monkey? Monkey का guardian is the zoo. Why not the zoo? Monkey का permission लिया था photo लेने से पहले. And photo का capture, photo का essence is the monkey and his expression. So it is his creativity, right? तो क्या monkey को मिलना चाहिए, by extension zoo को मिलना चाहिए उसका copyright? या you feel it's photographer की मेहनत है वो कि he got the right expression and he should get it?
In such case, there is a role of IP policy which we said. कि initially whenever you are hiring a photographer that time, as this morning is discussed, कि there should be some kind of agreement which should be signed. But anyhow, since वो monkey को कौन से angle में photo खींचा, तो वो तो photographer की ही creativity थी. तो इसके लिए I think in my personal opinion, photographer has a more authorship than.
Exactly. So in this case, sir, you are right. Photographer got the right, but there is another right in copyrights, what is called as the performance rights. Suppose I am giving a performance, Janvi takes my photo. She owns the photo, she has the copyright over the photo. But the right to take my photo, the right to my performance belongs to me. So there is a allied right in copyrights, एक अलग right होता है performance का. आपने बहुत बार देखा होगा actors है, musicians है, comedians है, they do a lot of unique original performances. और फिर क्या अनिल कपूर का the way he speaks has become very popular, right? And there are a lot of shows आप देखोगे उसमें उनकी mimicry कर रहे हैं. So there is a performance right belonging to Anil Kapoor. कोई जो वो term जैसे वो जकास बोलते हैं या जैसे वो express करते हैं अपने आप को या वो welcome में उनका the way of acting, no one can copy that without his permission. So in this monkey photography wala case, the way monkey is expressing himself, okay, monkey is not a very correct example to give, but the zookeeper has the right over how his photos can be distributed. Even if the copyright belongs to the photographer, it's the right of the zookeeper कि वो कैसे distribute होगा. So these are the unique rights in copyrights. We'll talk about the rights associated with the copyright part later on in the next slide probably. But yes, copyright में there are moral rights and economic rights. We'll talk about that. Types of rights. So moral rights is one category. The other rights that are displayed, the reproduction right, adaptation right, distribution, public performance and translation, all of this comes under economic rights. I'll explain each one in a bit detail. Reproduction is pretty simple. I made a story, I made a literary work. It's my right to copy it or to produce it further and distribute it further. That the right of reproduction, it belongs to me. No one can do that without my permission. In the case की story लिखी मैंने और for example as teachers you all made a research और एक book में one chapter belongs to you. You are the author of that chapter, but you gave your rights to the publisher to publish that story. So then the right of reproduction goes to the publisher. You have the right, which will come under a moral right, to be named as the author. So reproduction right होगा कि copy कर सकते हो आप. Adaptation. मैंने novel book लिखी, बहुत अच्छी story है, which got very popular. People want to make a movie out of it. People want to make a drama out of it. So that is my right to adaptation. They need to take my permission before converting it into any different form. भले then that movie converts from a literary to a cinematographic film, तो वो different copyright हो गया. वो copyright उनको मिलेगा, but वो change करने का right मेरा है. So they need to take my permission. चेतन भगत की बुक थी 2 states करके, sorry उसकी मूवी आई थी 2 states करके. चेतन बुक had made a similar story on that. उस story से मूवी बना and मूवी के लिए permission नहीं ली थी. तो he had filed a copyright infringement case. You need to take my permission to use my story. So that वो adaptation का right is comes under adaptation. Distribution, to sell it to the public, to use it, to distribute it further, that right is also comes under the right to distribution, which is an economic right. Next right is public performance. I explained a bit about public performance. I have made a story. The way I narrate that story comes under a public performance. So that right also belongs to me. Suppose, again, let's stick to the Chetan Bhagat example. उनकी बहुत wonderful story है. I am giving credit कि okay, this story is written by Chetan Bhagat and I am just narrating this story. That is my public performance. To do that also I need to take his permission. If I am doing it for my commercial benefit. अगर वो story narrate करके I am generating revenue, then I need to take his permission. The right of translation. English to Hindi, adapting it into different languages, that comes under the right to translation. And you need to secure permissions again for that. So all of these rights came under economic rights. What do I mean then by moral rights? Any idea, anybody? What will come under moral rights, copyright में? मेरी story है, मैंने
Tell you the story. No, whatever Chetan Bhagat has written in 2 states. I have heard those stories when I was a student in 94, 95. So actually speaking, whatever the incidents he has written down in that story has already known to every engineer that time. So morally, he is also not the owner of the story. So this is, can we consider this as a moral right?
This comes under a copyright infringement or how much, but moral rights will be different. But आपने जो example दिया to explain that, in this case the way, so for example, there is a calendar होता है. Calendar में 1 to 30, 12 months, everybody knows that. There is no original thinking on that part. But the way I have shown that calendar is my creation, is my creativity. मैंने वो calendar को कैसे display किया, that is my creativity और वो protective. In this case, चेतन भगत ने वो story कैसे portray की. भले आपको individual incidents पता होंगे कि engineering life में या college life में ये होता है, ये होता है, ये होता है. But उन्होंने उसको एक collection करके एक proper sequence में present किया और वो उनका creative लेबर था उस प्रोसेस में एंड ही गॉट द कॉपीराइट ओवर दैट. उनको ये चीज़ का कॉपीराइट नहीं मिल रहा कि ये एक इंसिडेंट हुआ उसका कॉपीराइट मेरा कि कोई और ये इंसिडेंट शेयर नहीं पूरी स्टोरी इन इट्स एसेंस अगर आप कॉपी कर रहे हो तो देन वो चेतन भगत का राइट आप इन्फ्रिंज कर रहे हो. सो वो एक इन्फ्रिंजमेंट का पार्ट हो गया. बट मॉरल राइट्स इज फॉर एग्जाम्पल आई एम गिविंग, मैंने बुक लिखी, मैंने पब्लिशर को बोला फाइन, आप पब्लिशर को मैंने बोला आप उसको यूज़ करो, आप उसको सेल करो, जैसे भी यूज़ करना है यू कैन डू इट. आई एम गिविंग ऑल माई कॉपीराइट्स अटैच टू इट टू यू. उसमें से जो भी रेवेन्यू जनरेट होगा आपका है. आई डोंट वांट एनी पार्ट ऑफ दैट. सो दैट इज आई एम गिविंग अवे माई इकोनॉमिक राइट्स टू इट फॉर सम, जो भी मेरे और पब्लिशर के बीच में अग्रीमेंट होगा ऑन दैट बेसिस. बट what right he cannot take away from me or I cannot give it to anybody else is the right to be named as the author. वो same publication में वो किसी को भी बेच आगे, but they need to mention that it is me, Hasti Chandarana, who has made that publication. So that comes under moral right, right to be named as the author. Another right that comes is right to not tarnish the reputation of original work. Suppose मैंने मेरे पब्लिकेशन या मेरा स्टोरी का किसी ने मजाक बना दिया, दे सेड एंड tarnished my reputation doing that, so that is not allowed. That will come under my moral rights. Exactly. So वो नहीं allowed है. Even if I have given away my rights, मैंने प्रोड्यूसर को राइट दे दिया आपको ये स्टोरी यूज करनी है करो, बट उस स्टोरी में और द वे ऑफ प्रेजेंटेशन में उन्होंने मेरी ही इमेज टार्निश की या मेरा रेप्यूटेशन ही बिगाड़ा जिससे लोगों को लगेगा कि ये मेरी आइडिया थी. दैट इज नॉट अलाउड. दैट कम्स अंडर मॉरल राइट्स. सो मॉरल राइट्स आर जो भी आपके पर्सनल वेलबींग से अटैच्ड होते हैं, आपके माइंड से क्रिएटिविटी अटैच्ड होती है एंड इट कैन पर्सनली अफेक्ट यू, कम्स अंडर मॉरल राइट्स. तो कॉपीराइट इज द ओनली यूनिक आईपी जिसमें देयर इज दिस डिस्टिंक्शन, और आपके मॉरल राइट्स कभी भी नहीं ट्रांसफर होंगे, असाइन होंगे. It will belong to you till the copyright exists in it. So that is a little bit about moral rights. Now comes copyright. हो गया, I explained about the rights of copyright. What are the cases where copyright protection does not exist? और someone infringes या someone copy करता है तो भी उनको allowed है. What are these cases? And these cases are very important from an academic point of view क्योंकि ये जनरली ये फेयर डीलिंग के जो प्रोविजंस है वो एजुकेशनल इंस्टीट्यूट्स को अप्लाई होते हैं. कैसे? फॉर एग्जांपल हियर आई हैव मेंशन्ड अ लिस्ट. स्टडी या रिसर्च के लिए मैंने मेरा आर्टिकल किसी ने यूज़ किया. आई हैव कम अप विद अ ब्रिलियंट थियोरी, आई हैव एक्सप्लेन दैट इन माय कॉपीराइट एंड समवन यूजेस द थियोरी to do their own research or to teach it to other people forward, then that is allowed. They don't need to take my permission to use that work. So that comes under an exception. मेरी स्टोरी पे किसी को क्रिटिसाइज करना है, रिव्यू देना है, they are allowed. They can do that. They cannot change my story, they cannot, but they can give their own views on it. And that will not be considered as infringement or copying of my work. They are allowed to do that. Events या news है, it is not considered a property of anybody. The news is meant to be consumed by all. For example, cricket, everyone watches cricket, scoreboard आता है. There was a case, कि पहले, this was 40-50 years back, where there was only one channel, DD, who used to show the cricket matches live. Also in metropolitan cities, Mumbai में हो गया, Delhi में हो गया. In the interiors, there was no way of seeing the score या match क्या है, क्या status है, किसी को नहीं पता था. तो what the radio broadcasters used to do, वो लोग TV से देखते थे and they used to pass the information और radio पे publish करते थे कि this is the score, इतने runs हुए, ये हुआ. अब क्या हुआ, ये TV channels ने इस पे केस डाल दिया कि you are copying, आपने मेरे channel से देखा और मेरी information आप आगे pass कर रहे हो. So this went to court and the court said कि it is reporting of a live event. जो हो रहा है वो दिखा रहे, आपका प्रॉपर्टी नहीं है. स्कोर जो हुआ वो आपने उसमें कुछ भी नहीं किया. यू हैव जस्ट रिपोर्टेड दैट स्कोर. कोई सेम रिकॉर्डिंग फोटो लेके उसका वीडियो लेके सेम रिकॉर्डिंग दिखा रहा है, यस इट्स कॉपिंग, बट सिर्फ वो न्यूज इवेंट बता रहा है कि अच्छा दिस इज द स्कोर ना, दैट इज नॉट कंसिडर्ड इंफ्रिंजमेंट. सो दैट इज व्हाट कम्स अंडर रिपोर्टिंग करंट इवेंट्स. The other most important is teacher-pupil interaction. For example, आज का session है, whatever knowledge you gain from this information, and if you pass it on along ahead, I cannot claim copyright infringement over that. I cannot claim कि मेरा information आप use करके किसी को आगे pass कर रहे हो. Because it was for educational purposes, it was for instruction purposes, and you are not using it to gain commercial benefits out of it. आप भी आगे वो information किसी को educate करने के लिए use कर रहे हो, then you are allowed to use it without taking my permission. So that comes under the educational teacher-pupil instruction. Again, in the same umbrella, educational public performances, any of this performance today would come under the category of educational public performance. And journalism, in the category of reporting current events, will come incidental inclusions or journalistic use. One very important thing was Oxford की book है. They have one Oxford's research book costs, for example, 10,000 rupees. You take one chapter of that book which you know your students want. Now वो chapter मैंने उसका, I have 50 students in my class. I took a photocopy, 50 photocopies, और मैंने मेरे सारे students में उसको distribute किया. Would that be copyright infringement or no, and why? Oxford has done a lot of research, उनके professors, उन्होंने बहुत सारा material input डाला है to come up with that theorem or to come up with that publication. And it is used for students only, but वो book is very hard to get access to. तो आपने क्या किया, आपके पास वो book थी, आपने notes circulate कर दी, उसकी copy circulate कर दी. Is it allowed? Do you think?
It is not. I remember there was a case, ये जो अंधेरी में photocopy center है, he was selling, he was photocopying a book. The book cost was somewhere 5,000 rupees and the photocopy is available for 300-400 rupees. So there was a police case and it has came in the newspaper. तो जे पता नहीं आगे क्या हुआ, लेकिन
Okay.
Yeah, revenue तो फिर obviously it will be infringement.
Okay. Okay. Ma'am, आपने भी starting में you said it's not infringement. What was your reasoning?
I said only for educational purpose you are distributing to students. You are not commercializing it. You are not earning from it. So it doesn't come under that. In my
That shouldn't be infringement in your opinion. Ma'am, what do you think?
No, I agree with
That it should be infringement. Anybody else, any other reasoning? अलग अलग है, फोटोकॉपियर को इन्फ्रिंजमेंट होगा, टीचर जिसने बांटा उसने इन्फ्रिंजमेंट नहीं किया. डज एनीवन थिंक कि ऐसा कोई सिचुएशन हो सकता है? एनीबडी विथ एनी अदर बिफोर आई टेल यू व्हाट रियली हैपेंड इन दिस केस? नो? Okay, so this has been a very, sir ने जो case बताया, this happened in Mumbai, but इसके पहले there was a very famous, it's considered sort of a landmark case in copyright infringement. Delhi University and I don't remember the name of the photocopy center, उन पे case file किया था Oxford publication ने for doing the exact same thing which I explained in the situation. Students were not getting the benefit of that publication, उनके पास वो research नहीं थी, तो what the Delhi University did is, went to the photocopy, 100 photocopies ली and उन्होंने distribute की. Now Oxford ने जैसे आपने बोला कि it is for commercial gains, it should be considered infringement. On the same case, Delhi University ने बोला कि students के लिए it is for information, it's for education purposes, it should not be considered infringement. What the court decided was it is not considered infringement because they wanted to balance copyright के rights and the right to education. So if it is done for non-commercial purposes, वो photocopy center is not allowed to make 1000 copies और फिर बाद में उसको black में बेचना. They did a limited number of copies for the students which was only available in the educational institution, not outside. You cannot just copy and forward it further. वो allowed नहीं है, but only for educational purposes if the teacher or the university is doing so and circulating it, then it is allowed. No, if the university is selling it, then it would be commercial use. If no, the whole concept is if they give it to the students for their education purposes without charging, the whole, or in the concession or at a very, if it was available at 6,000 rupees and Xerox ka paisa liya, but they're not making any profit out of it, then it is allowed.
In my case, if you consider the case with the Delhi University, since the institution Delhi University is there to impart education.
Exactly.
But now in the case which I am discussing, this was a photocopier.
Yes.
And he is having a machine with which is having a scanning memory. So he had stored that.
That is not allowed. That I agree. Yes. In this case also, photocopy was also considered a liability or a person who infringed. But उन्होंने सिर्फ उतनी copies ली थी जितनी वो educational institution को चाहिए थी. Then he is allowed to do that. But if he does कि मैं इसके, I now have the rights of that and I have that information. Now I will sell it to everyone and anyone possible for a profit. That is not allowed. So the courts made a very clear distinction कि for non-commercial purposes, if you are using for educational non-commercial purposes, it will not be considered copyright infringement. But if you gain any commercial benefits out of it, it will be considered an infringement. So this was in the times of physical documents when they were so important. Now the whole world has shifted towards digital and online. So the same rules apply. If you find a PDF, और उसको आपने directly copy paste करके आपने open source पे डाल दिया without taking permission, that is not allowed. That is for any commercial purpose, it is not allowed. So we have to be very, very mindful when we are accessing any of the digital copies, PDFs, review articles, even if they are open access. One right, the moral right, I said, the right to be named as an author. आप अगर आपके students in their papers, if they are quoting someone without giving attribution to that person, without naming them as the author or properly citing that person, that is not allowed. Even in cases where citation is done, ideally in a world where all the laws would be followed, you have to take the permission of the author. But obviously the author can't come to every city and check कि किसने अपना paper लिखा. But on a digital platform, it's easier to identify कि मेरा citation किसने copy किया. You have to take the permission of the author to use it. He will grant it to you, but you have to take the permission. So that is what the Copyright Act says. Yes. Book.
Only copying the storyline or the copy everything from the book. That is considered as an adaptation, or only somebody takes a soul line and present in a different way with the changing the name of the characters also. So does that come again?
No, changing the names of the character, but still maintaining the storyline, still having the same plot twist, still having the same ending, will still be considered copyright infringement. ending, but so then the copyright infringement in that case is very case-to-case basis. How much percentage of copying has happened? There are cases ki 90% copy nahi kiya tha. They only copied 10%. For example, there is a 5-minute song. I just copied the 10-second hook line. I can say it's not copyright infringement. मैंने सिर्फ 10 second out of a 5 minute. But if that 10 second is what makes that song so popular and so original, then that will still be considered copyright infringement. In the same case, अगर मैंने out of 5 minutes, 3 minutes का part copy किया, only 2 minutes का नहीं copy किया, but I have changed it and that 3 minutes did not have an impact on the originality or the creativity, or it was already known. Suppose मेरा song है 5 minutes का, उसमें से 3 minutes का दूसरे songs भी similar है, दूसरे story lines भी बहुत similar है, then that will not be considered infringement. So what original content you have brought, that is analyzed every time. So storyline की plot है कि okay, there is a normal storyline, there will be 2 characters, there will be a middle जहाँ पे first it will go to a high, then there will be some issues in that, फिर एक plot change होगा और conclusion आएगा. That is a basic storyline. उस पे मैं copyright claim नहीं कर सकती कि this is the story and this is how the process of the story will go. That there is no copyright over that. आपकी actual expression क्या है? So again, very important, ideas are never protected. The way you express your ideas in a different form, literary, artistic, sound recording जैसे भी, that is what you get protection over. So that
and for how many years the copyright will?
So copyright protection is one of the longest protections. In cases of literary works, lifetime of the author plus 60 years तक का protection मिलता है. 60. In cases of films, songs, musical recordings, 60 years का protection मिलता है. From the date of publication of that song या film, 60 years का होता है. And for literary works, it is the lifetime of the author plus 60 years. मतलब रविंद्रनाथ टैगोर जी ने जो स्टोरी लिखी थी, उनके पूरे लाइफटाइम में उनके पास वो कॉपीराइट था, और अब कोई और उसको कॉपी किया आफ्टर 60 इयर्स, उनके जो heirs हैं उनको भी उसका इकोनॉमिक बेनिफिट मिलेगा. So that is how long the term of protection of copyright is. Exactly, sir. There happens also that the painting, अभी painting में there is a very unique concept that happens. Van Gogh एक बहुत famous painter थे. When he was alive, उनके paintings को किसी ने कोई भाव नहीं दिया. No one considered it as valuable. So no one gave any money to his painting, no one bought his painting, and he died by suicide, if I'm not wrong. What happened is 100 years later, someone discovered and someone appreciated. So copyright protection end ho gaya hai. Why should I get any economic benefits out of it? But the courts ruled that even if a painting that later gets popular and then later has some economic advantage to it, you will have to give that economic advantage to the original painter or their family or the heirs, jo bhi hai. So in cases of artistic work also, that protection exists. So that is, copyrights in that way is very unique and interesting as compared to the other IP rights. Just a little bit of example, yes. So सबकी अगर ड्यूरेशंस अलग-अलग हुए, suppose literary has full lifetime plus 60 years, yes. And music, if I'm not wrong, that has 60 years or something like that. Yes.
So would that be lifetime 60 years plus 60 years or?
So for example, जो lyrics है, that belongs to the lyricist or the one. So he will get that term of protection. The producer who has made that song will get a protection for 60 years only. So after after the protection ends, somebody else can use the same film, the same music composition after 60 years, but they still cannot use the lyrics because that protection still holds, the lyricist still holds that protection. So that is a clear, and in the terms of social media where there are reels made, it's very easy to just copy. So there was one very interesting case which had happened recently. Shakira karke, there's one female artist. Her dance moves are very popular. The way she does her enactments and her choreography is very unique and creative. She claimed copyright protection over that. Kisi ne Instagram ya TikTok pe made the same choreography and they got millions of rupees out of that TikTok performance. Shakira claimed copyright infringement over that. That is my public performance, that is my choreography, my creativity. The rights belong to me, you need to give me, you need to take my permission. So in this digital world, there are a lot of implications, and that is the power the copyright holds. I was talking about the copyright exemptions. I've just made a little bit of a brief of what you can do under fair dealing and under the exception and what you cannot do. So what you can do is compile readings strictly for students and limited copies to class size, as I mentioned. Charge only the actual reproduction cost, you can do that. Keep access behind campus credentials, destroy any surplus after the semester. So you don't use any of that material for your commercial gain. All of that is allowed, you can do that. What you cannot do is upload an entire textbook or a PDF to an open source without the owner's permission. You cannot do. You can select parts of it which you think are important for your student and share that to a limited class size, but you cannot make it available to open for public to consume. That is not allowed. That is not covered under the exemption. Sell the same packets in the marketplace. The photocopier case sir was explaining कि वो photocopy sold it to other markets, which is not allowed. Assume your fair dealing will cover everything and anything. आपने आपके campus के अंदर कोई नया movie दिखा दिया without the permission, that is not allowed. For educational purposes, if you show anything, that is allowed. But for entertainment purpose or for commercial purposes out of that, you cannot do that. Or for example, it's very easy ki this movie is for 100 rupees or I have to pay 1000 rupees on Prime Video or this or that. I will just take a recording of that and put it on internet and everybody can access it. That is not allowed. That is still considered copyright infringement. So these are some of the do's and don'ts for claiming the copyright exemption that there is. This was about copyrights in general. Anybody has any doubts, questions for copyright specifically?
So just you gave example of Shakira. So Shakira claimed that these steps belong to her. But
yes.
What if she did not even register for that as for copyright, and so she discovered that someone has copied, and can she claim immediately?
Yes. So as I mentioned in the beginning, copyright is the only right. The right exists as soon as it is created. As soon as Shakira came up with the idea or that choreography, copyright exists with her.
Even though no documentation is
Even
there.
if no documentation or formal registration helps for evidence purposes. How will she claim कि मैंने ये date पे ये choreography महीने पहले की थी and not someone else? She needs to have some or the other proofs when she goes to court. So this copyright formal registration only aids in that evidence. This is not the case for patents or industrial designs. Patents में जिसने file किया उसका ownership है. That does not apply to copyrights. Yes, ma'am.
So, if she had not, documented it,
It would become harder for her to prove, but if she would be able to successfully prove and convince the court that it was her own creation, yes, she will get it. That is allowed.
So one more question, ma'am. If the copyright you have taken in India, can it be valid all over the world?
Yes, again, copyright a unique right. It exists all over the world. Even if you take the protection in India, it's still because there is a convention where all members are party, all other countries are party to it, the Berne Convention, under which if you even take protection in India, it will still serve as a purpose. Again, opposite to patents. Patents mein whichever country you file in, you get that protection. That is not the case in copyrights. Sorry, sir? Yes. Yes, sir. So this Shakira example was for that, the choreography, the dance steps. were also given protection. Especially in this day and age of reels where 30-second one dance step can also get you so much economical advantage. In this case, even if one dance step was copied, it will still be infringement and you still get protection over your one original dance step. So that is, but films and choreographers allow that because it just makes their own dance much more popular. So they generally do allow people to copy the dance step. But in cases where they feel they're not reaping the economic benefits out of it, they can claim copyright protection and infringement in this case. Any other questions on copyright?
Somebody's videos are already existing and people make those shorts, right?
Yes.
And if they start earning more than the original video.
Yes, so this was currently in the last month or so, YouTube has come with a policy where these types of shorts are no longer allowed or they will no longer be monetized. Ma'am, you correctly pinpointed the problem that was occurring currently, that long videos the original creator made and they took 30 seconds and claimed it under copyright exemption, but they were still getting monetary benefit out of it. So that is how now YouTube has stopped that policy. If they find there is an infringement and they're copying, then the content will not be monetized and it will be taken down out of the website.
And if they take the same content but present it in their own style, then it is...
Then it depends if that concept was, because concept as such is not given a copyright protection. The protection lies again in the expression.
Okay.
Concept is considered as an idea. So an idea or a concept is usually not protected. The expression is what is protected. So in this case, if the expression changes, there is no infringement.
Ma'am, one more question. Like we have methodological serials, Ramayana, Mahabharata. Earlier there was there, now they are repeating and in a different. So is there any copyright?
Yes. So with respect to religious texts and ancient traditional knowledge that was already known, no one can claim copyright over it. So nobody can claim a Mahabharata story is mine and I have the copyright. But the way they show the show, the way they express and the way the actors perform, or the way the music composers have a background music, they can claim copyright over that. But Mahabharata as the story, koi copyright exists nahi karta in that case. That is for everybody to consume. Whether it be in a literary form, in a musical, in a film, in any way that is shown, there is no copyright over the story of Mahabharata. But if someone makes a song, so royalty happens when there is licensing. Going back to my previous example of Chetan Bhagat, if he made that story and someone wanted to make a film out of it, वो producer ने और Chetan Bhagat से permission लिया to use his story, then the producer will give royalties to Chetan. Because singers also have copyright protection, the way they expressed. Under their musical work, they also have a copyright protection. And what happens in the music industry is that all rights go to the producer. The singer is often left without any rights. So in India and other places as well, there are copyright societies. Now, how will one singer find out that yahan pe bhi someone is playing my song over in this city, in that city, in this hall? How will they? So they have built copyright societies where if you want to use any, so the copyright societies will have the rights over 100,000, 10,000 songs. And then if you want to play any song, या आपको एक hotel में songs play करने हैं, or you want to use songs in weddings, right? You have to take permission from that copyright society. You have to pay a licensing fee, and then that copyright society will distribute that money to the singers and the rightful owners of the copyright. So that is a provision of a copyright society that exists in the Copyright Act, to have a common platform for creators to leverage their copyright protection. So in that case, singers can also claim their copyright protection. They also have, not on the lyrics of the song, but the way that was sung and the whole song, they also have the right over it. Yes, anybody? Yes, sir. So there are different models and different ways in which the producer distributes the economic divisions of the work and the money that they receive. That again, there is no set rule or law for that. It depends on the agreement that the singer and the producer and the composer have within themselves.
Initially by the other singer, and whenever it is something like included in a movie or in any kind of playback kind of something is there, so at that time some higher, that means the famous singer has just sang. So in that case there is no any such kind of
no, that singer needs to take the permission of the original.
but it doesn't happen till now actually.
Yeah, that is because people, the main issue of copyrights or any IP right for that matter is the lack of awareness. People don't know that they have the right to claim. People don't know that I have a copyright to my name, and I can, if someone is copying my song, I can go and sue them or I can file for infringement. So that was the issue that I was facing. But now the remixes that are being made, for that also you need permission. There was a song currently, I don't remember the song, but the old singer refused making a remix of that song, even if they didn't have any economic rights. The economic rights of the song were belonging to the producer, but a remix would change the meaning of the song, and under the criteria of moral rights, the singer refused to give it. So in that case also, if a remix would have been made, it would be copyright infringement. If they have given away the rights, there will be no economic, monetary or royalties given. But the right that, okay, this original story was done by so-and-so author, that right will remain with the author. Depends on the agreement, obviously, between the two parties. If the writer did mention that I want some, if any adaptation of this work is happening, I still want economic. Dawn 2, yes. Yes, so again, the screenplay, if it was not changing the storyline, the concept, the story of the movie, there were only different actors with limited changes in the script. In that case, the screenplay. Again, the screenplay, original screenplay, the writer has moral rights over it. I don't want you to change the way it fell to the public. I still have rights over that. So those rights have to be taken. And it is in copyright, because there is so many differences, what becomes very, very important is the agreement that you sign between the two parties. Because there is no formal scope of protection under copyright law. It is a very wide term. So the agreement, whatever the agreement mentions, is what is considered. So this was all about copyrights. Now we move on to the second part, and this will be very short because I thought copyrights would be more important, and I had discussed that a bit more in detail. We'll now move on towards trademarks. Trademarks are essentially your brand identity. Anything that identifies your brand can be protected as a trademark. It could be your name, it could be your logo, it could be a color, it could also be the smell. There is a French perfume company who have trademarked the smell of their fragrance, because from that smell, any customer will recognize, okay, this is this brand. So that can also, so anything and everything that can be that can identify your brand is protected through trademarks in very, very simple terms. So examples of some famous ones is Mercedes-Benz. Even if you just see the three-spoke logo, you know it is Mercedes. That is you don't need to have or write Mercedes-Benz for anybody to know that it is Mercedes. So that is your trademark. The M mark is very, very well known now to McDonald's, Ford, Google. So Google is now currently facing a unique challenge. Google is a brand, it has a trademark over it. What has happened now is, when I say I want to search something, I often say I will Google it. So that is considered as a trademark dilution. People have started using it as a dictionary word. So now Google has to Yes, so people might search on Yahoo, or people might search on some another search engine, but still say that it is, I'm Googling it. So there was an attempt where the term Google, they wanted to add in the WebVM dictionary, and Google opposed it. They said it is not a dictionary, it's not a common word, it's a brand identity. It is my brand. I don't want it to make it a common word. You all know aspirin, the word aspirin, it's considered a fever medicine. Aspirin was originally a brand. They had come up with a new brand name. It was the name of the drug was something else. This was a brand name, but it became so common that you lost protection, your trademark identity was lost. The same way, whenever we say I want to copy some document, do we say photocopy or do we say Xerox? We say Xerox. Again, Xerox was a company, it was their brand. The term for copying something is called getting a photocopy of the document, but we have used it synonymously with now Xerox. So that is how you also lose protection of your brand, but the whole purpose of trademarks is to identify your brands, to separate them from common words. So usually brands would signify your quality, your reputation, your goodwill in the market, and all of that is associated with trademarks. The different types of trademarks that can exist. So trademark is applied in between 45 classes. Like in designs, yesterday Janvi was explaining. Similarly, trademarks may be classes hote hain. There are 1 to 45 classes. Class 1 to 35 are for different types of goods. For example, I'm a pharmaceutical company, then my products or my brand will be registered in class 5 of trademarks. If I'm into services, then wo class 35 to 45. Legal services, then it's considered a service. That will be applied in class 42. So that way there are different classes. So a goods mark or a trademark for a good is considered as a class 1 to 35 mein fall kiya, then it's a goods based. A service mark is when you are distinguishing between two services. There is another mark called as a collective mark. Now what do I mean by collective mark? Have you all seen all advocates or all lawyers use that same white ribbon and black logo? Or all CAs use the exact same way to show CA. Now, is that trademark owned by one person, or anybody who's a CA can use that mark, or anybody who's a lawyer can use that? So that sort of a mark is called as a collective mark. It is owned by the entire association or by the entire group and does not belong to one single person. But that association can decide and file a case on someone if they don't. If I'm not a lawyer, I have not obtained the registration and I still use that logo, then that association can file a trademark infringement on me. So that is called as a collective mark. Then comes the certification mark. ISI standard, gold standard. So there are, if you want to apply for that certificate, if you get that certificate, you can use that logo for your brand as well. So that is considered as a certification mark. What do I mean by well-known marks? Now, as I explained, class-wise hota hai trademark registration. So what can happen is, if I have come up with a new company, not a lot of people know that, and my brand is called as Artemis, for example, and I did it to file for legal services. Someone can use the same word Artemis in another class, class 5 mein kar liya for their medical products. I cannot claim trademark infringement for that because our goods are different, our services are different. So that is the general rule of thumb for trademark registration. But this is overridden in the case of well-known marks where वो protection of brand identity इतना strong हो गया कि you cannot use it for any of the classes. So I cannot use McDonald's, for example, has become well known. I cannot make a car manufacturing company and name it McDonald's tomorrow because it has gained so much reputation in the market. So that is well-known marks. I think we are done with our time, so we'll continue in the next. Yes.
Yeah. So if it's a software company and they have a logo or a trademark, then that will be registered under what class?
So it will come under software, comes under class 42 if I'm not mistaken. If software as a service is being used, but they came with a computing program or a product, as a product they are selling that software, then it would come under class 9 for software.
The logo of that company.
Yes.
Who does softwares or web solutions or whatever.
Yes, so if they do service also, they do products also, they can file in both the classes as well. It is not limited that one brand can file only in one class. Whatever goods and services they are selling, they can apply for registration in all of those classes, the applicable classes. Yeah. Maybe we'll continue more about trademarks in the next session. I'm here the entire day, so hopefully I will bore you all by the end of the day. We can continue it later. Yeah. Thank you. Just to have this, I'll give a very, very brief one-word difference first, and then we can go into the details. Patents protect technical solutions. Copyrights protects creative expressions. Trademarks protects brand identity. Industrial design protects the aesthetic features or the look and feel of a product. And trade secrets protect your confidential information. So in one word, this would be the difference. If I were to go in a lot of detail or some detail, patents are anything novel, inventive and has industrial applicability with a technical new solution to it that can be patented. Versus a copyright is anything creative and original. For original works here, copyright does not see if it is novel, it has some inventive concept. As long as it has been made by you, it can be copyrighted. So the bar for copyright is very different. When they talk about original or novel, that is not the same as what you mean when you talk about patents. For copyright, originality just means it has to be done by you, and it has some difference than the existing work. How different is it? All of that is not assessed in copyrights. Trademarks will protect whatever identifies your brand. As we discussed, your name, your logo, the color, smell, everything and anything. If you all would know the Taj Mahal Hotel at South Bombay, everyone might be aware of the Taj Mahal, Taj Hotel, right, by Tata. They have trademarked the photo of Taj. The architecture has been trademarked as a brand identity, because whenever you look, even at a film, if you see that hotel, you would know it is a Taj Hotel. So it is identifying their brand, that means it is trademark. So that is what trademarks is. Industrial designs. In India, designs only and only protect your aesthetic 3D feature looks of it. No function, no means of it is protected. The industrial design only gives you protection over how it looks, and it should be tangibly visible, and that is the criteria for industrial designs. No, in that case it would not come under industrial design. That would, so circuits are another integrated. No, unless it can be applied to a product or a commercial tangible product, it would not be qualified as an industrial design. It would, you can then maybe your flowchart or your artistic drawing, you can go for copyright protection, not for industrial design. And your trade secrets, so trade secrets again we very briefly talked about it. Trade secrets are not a very defined form of IP protection. There are no laws per se for it, but any confidential information which could include your business information, which could include your technical know-how which you have not disclosed in patents or anywhere else, all of that comes under trade secrets. And the very simple idea to keep a trade secret ongoing is to keep it a secret. That is, minimum people should know about it. If you are entering into a partnership with anyone, you may ensure that through legal documents such as a non-disclosure agreement, you protect your confidential information. Once that information is out, it is out, your trade secret is lost, and then you cannot claim any protection over that. If someone harms you or deliberately leaks that information, you can sue them or file for a breach of agreements or breach of confidence, but there are no other. Yes, yes. So during those letter of intents, I always advise the faculty members and students in my institute to have a non-disclosure agreement in place where you bind the industry as well to not leak. Even if we don't enter into a project later on, still that information is mine. You cannot use that information to develop your own product, cannot give it to anybody else. That has to be so it's the first criteria and the first agreement that we try to ensure is in place.
Suppose I am not working in that industry. Suppose spice is making industry, manufacturing. They have certain composition of spices, and that's their trade secret. Because of that, their spices are selected. So if suppose, like I came to know about that formulation, and if I disclose it, if I use for my own commercial purpose,
then the trade secret will be lost in that case, because there is you didn't do it, you didn't cheat the company to get that trade secret, you figured it out on your own, so that trade secret is lost. So that information is lost.
then whether it has any legal action.
No, there will be no. So that is the con of a trade secret, because you will have no other legal protection to it. Once it is in the public domain, it is in public domain.
If I go for patenting, if I go for some other thing,
Yes, then there are legal implications, but in trade secrets there are no legal implications if just randomly someone finds out. The best kept trade secret in this century is the secret recipe of Coca-Cola. They have guarded that secret. Only 3 executives of the company at any point of time know the recipe of Coca-Cola. They are not allowed to travel together, and the actual handwritten recipe has been kept in a vault. So they have gone to such extreme measures to protect their trade secret. Yes, so that
Hello. How to obtain the copyright?
how to?
Obtain the copyright.
So copyright registration, copyright office has their website. You can apply for copyright on your basis. If it's a literary work, there is a form called Form 14. You have to apply, include all of your details, submit your work, and pay the requisite government fee, and that's how if there's any objection, that is answered. So that is the normal due course.
It is under the patent only?
No, Copyright Office has a separate website.
Okay.
It is still under the government, the body is same, but they have a separate mechanism to handle.
And how much is the fees?
The government fee for literary work is per fee 500 rupees, and other attorneys and law firms also do the copyright work. So they can also assist you in filing.
That goes to the copyright somewhere to verify the
To
verify the documents.
so the Copyright Office does their own verification of if it's an original work or not, and some offices will also do their own search before filing. If it's a agency or an attorney that you are hiring, they will also advise you on if it's copyrightable or not.
Are you talking about the Rajaram Mohan Rai ISBN number? You talking about that website?
No. I'm talking about a general, the Copyright Office. Like the Patent Office does their own examination, the Copyright Office does their examination.
No. For the books to get the copyright, there is a government website, Rajaram Mohan Rai ISBN.
Okay.
So there we have to register, and we have to upload the first and back page of the book, and we get a ISBN number and the copyright.
ISBN number is received, but there is no copyright received. Copyright registration only happens through the Indian Copyright Office. There is no other website that gives you a copyright. You can always write in, you might have seen that books have that declaration, a C mark and written copyright reserved. That does not mean that they have a copyright certificate, that just means that they are going to protect their copyright. You can also add that to your publication, your book. But to obtain the copyright certificate, you have to go through the Copyright Office only.
Okay, thank you.
Depends on the type of the work. If it's literary work, you have to file 2 copies of your work, and if for painting, the painting as well, and if the author or the painter is not the one who's applying for a copyright, you have to get a no objection certificate from the author or that painter saying that I am allowing this person to file the copyrights and I've given all rights to this person to apply for a copyright. So it's a very fairly simple process. the name and the original date and date of publication, all of that has to be mentioned along with the copies of work. Yes, so yes, so it is verified by the Copyright Office. So usually the time taken is 4 to 5 months, and once it is approved by the Copyright Office, again like trademarks, there is a 1 month waiting period. If someone else wants to oppose if they feel that this is a copied work, they can oppose it, and if it's not, then the copyright certificate is issued. I think that brings me to the end of today's session. Thank you very much for having me, and you all can always reach out to me for any queries. Thank you.